Every system, whether it's rules for a game or how a business runs, or definitely in the legal world, it really hinges on rules and deadlines, doesn't it? They give us structure, predictability.
Absolutely. But it gets tricky when rules clash or when,
Mhm.
following one rule to the letter leads to an outcome that just feels, well, wrong, or at least unduly harsh.
It's a real balancing act. How do you build a system that's clear and certain, but also flexible enough for, well, real life?
Exactly. And that tension, that's right at the heart of what we're digging into today.
We're doing a deep dive into a specific South African court case. It's a Supreme Court of Appeal judgment from 2016, Trustco Group International versus Vodacom.
Yeah, the judgment itself is our source material. And it's quite fascinating. It really shows you how judges wrestle with the exact words of laws, the regulations underneath them, trying to figure out what they really mean when they seem to pull in different directions.
So the core topic here is about the power of an official in this case, the Registrar of Patents, to extend time limits.
Hmm.
And the big question, the really juicy part, is whether a detailed rule, like a specific regulation, can actually cut back or limit a broader power given in the main law, the act itself.
Think of it like the main company policy says your manager can approve late reports, right?
Okay.
But then a departmental memo says if your report is late, it's automatically rejected, full stop. Which one wins?
That's a perfect analogy. So that's our mission today. Unpack this Trustco v. Vodacom judgment. We'll follow the story, this fight over a lapsed patent, and see what the court's decision really tells us about interpreting rules, deadlines, and the whole hierarchy of law.
Right. Expect some aha moments about the real nitty-gritty of legal procedure and why it matters so much.
Okay, let's set the stage. This whole thing starts with Trustco. They owned a South African patent.
Patent number 2 yellow 1 003199 specifically. Now, patents aren't free forever. You have to pay renewal fees to keep them active.
And that's where the problem started for Trustco. They didn't pay the required renewal fees on time.
Yeah, simple as that. And the consequence under patent law is pretty straightforward. Miss the payment, the patent lapses.
Which happened to Trustco's patent on November 26, 2011. Lapsed. Gone. At least for the moment.
Now, losing a patent, that's potentially a very big deal for a company. But the Patents Act, it does offer a potential lifeline.
Yeah, Section 47(1). It says if your patent lapsed because you didn't pay the fees, you can apply to the Registrar of Patents to get it restored.
It's not automatic, though. The registrar has to be satisfied about a couple of things. First, that the failure to pay wasn't intentional.
An honest mistake, basically.
Right. And second, that there wasn't any undue delay in applying for restoration once the mistake was, realized.
So Trustco does this. They apply for restoration. And part of that process, a required step, is advertising the application.
Correct. It has to be published in the official patent journal. That happened on June 26, 2013. The idea is to let others know in case they want to object.
And guess what? Someone did want to object. Vodacom.
Vodacom saw the notice and decided to oppose Trustco's attempt to get the patent back. They filed their formal notice of opposition on August 26, 2013.
Okay, so Vodacom opposes. That triggers the next step for Trustco under the rules. They have to respond formally.
It's called a counterstatement. Think of it like their defense against Vodacom's opposition.
And here is where the crucial deadline comes in. Regulation 83. It states very clearly that this counterstatement must be filed
within 2 months of the filing of service of the notice of opposition.
Okay, so let's do the math. Vodacom filed on August 26th. 2 months later is October 26th, 2013.
But wait, October 26, 2013, that was a Saturday.
Ah, right. And the Patents Act, like most legal systems, has a rule for that. Section 88(2). If a deadline falls on a weekend or public holiday,
it rolls over to the next business day.
Which means Trustco's actual deadline for the counterstatement was Monday, October 28, 2013.
So what happened on Monday, October 28th?
Well, they missed it. Trustco did not file their counterstatement by the deadline.
Okay. But they didn't just let it sit forever. 2 days later, on October 30th, their attorneys contacted the registrar.
And what did they ask for?
They requested a 2-month extension to file that counterstatement.
And the registrar, remember, this is the official in charge of these processes.
The registrar considered it and decided, yes, okay, granted the extension.
And that decision, that granting of the extension after the deadline had passed, that's what Vodacom objected to.
Exactly. Vodacom appealed the registrar's decision to grant the extension. They took it to the next level. The Commissioner of Patents, who in this instance was a high court judge, Magoba J.
And it's really important to stress this point. Vodacom wasn't initially arguing they were prejudiced by the 2-day delay or even by the potential 2-month extension.
No, their argument was purely legal. It was about power. Did the registrar have the authority under the law to grant that extension at all, given that the original deadline had already passed?
Which brings us right to the absolute core of this legal dispute. Where does this power to extend time come from? And did Regulation 83 somehow take it away here?
Okay, the general power comes from Section 16.2 of the Main Patents Act. Let's look at the key wording.
It says, whenever by this act any time is specified within which any act or thing is to be done, the registrar or the commissioner may save, where it is otherwise expressly provided, extend the time either before or after its expiry.
Okay, a few crucial bits there. May extend the time. That sounds discretionary.
Yes.
Either before or after its expiry.
Sure.
That seems really broad, covering situations like Trustco's where the deadline was missed.
But then there's the catch, that little phrase, save where it is otherwise expressly provided.
Meaning, this broad power exists unless some other part of the law specifically, expressly says, nope, not in this situation.
Okay, hold that thought. Now let's look again at Regulation 83, the specific rule about the counterstatement deadline that Vodacom was relying on.
It says, if the counterstatement isn't lodged in time or within such further period as the registrar may allow, then what?
The application shall be deemed to be abandoned.
Deemed to be abandoned. That's the key phrase Vodacom hung their hat on. It sounds automatic, doesn't it? Miss the deadline without an extension already granted, and poof, the law treats the application as if Trustco just gave up on it.
So Vodacom's argument, which actually persuaded the High Court judge, Bj, was basically this. Regulation 83 is mandatory. You have to follow it.
And that deemed abandoned part, that, they argued, is the otherwise expressly provided exception mentioned back in Section 16.2.
Their logic was, the moment Trustco missed the October 28th deadline, Regulation 83 kicked in, the application was legally deemed abandoned.
And at that precise point, the registrar's general power under Section 16.2 to grant an extension after expiry was switched off for this specific situation. Regulation 83 overrode Section 16.2 once abandonment was deemed.
The High Court also expressed a concern, didn't it, about certainty.
Yes. The judge worried that if the registrar could grant extensions after this deemed abandonment, applications could potentially be revived long after the fact, leading to uncertainty, maybe indefinitely.
So the outcome at that stage, the High Court agreed with Vodacom.
Right. They upheld Vodacom's appeal, finding the registrar couldn't grant the extension after the deadline passed because the application was already deemed abandoned by Regulation 83. Trustco's restoration attempt was dead in the water.
Ouch. Okay, so Trustco loses round one, essentially. But they didn't give up. They believed the High Court got it wrong.
So they took the case further, up to the Supreme Court of Appeal, the SCA, South Africa's second highest court.
And the SCA looked at the whole thing fresh, and, well, they came to a very different conclusion.
Completely different. Their reasoning really gets into the fine points of how you interpret laws and regulations together.
Let's unpack the SCA's thinking. Point one. They looked, again, really closely at the wording of Regulation 83 itself.
Remember how it said the application is deemed abandoned if the counterstatement isn't lodged in time, or was the next bit?
Or within such further period as the registrar may allow.
Exactly. The SCA highlighted that phrase. They said, look, the regulation itself acknowledges and points towards the registrar's power to allow a further period.
So the regulation isn't setting itself up against the registrar's power. It's actually structured assuming that power might be used.
Precisely. So the SCA concluded Regulation 83 does not contain wording that otherwise expressly provides a limit on the Section 16.2 power, especially not after the deadline. It doesn't fit the exception criteria in S16.2. It actually refers to the S16.2 power.
That's a subtle but really crucial reading of the text. What was their second main point?
This was a big one, the hierarchy of laws. You have the act passed by Parliament, and then you have regulations usually made by a minister under the authority given by the act.
The act is the boss, basically.
Right. And the general principle is that a regulation, which is subordinate legislation, cannot override or contradict the main act it's made under unless the act specifically says it can.
So, interpreting Regulation 83 in a way that cuts down the broad power explicitly granted by Section 16.2 of the Act would be, as the court put it, letting the tail wag the dog. You interpret the regulation in light of the Act, not the other way around, unless the Act is absolutely clear that the regulation has that limiting power. And here, it wasn't.
Makes sense. Were there other points?
Yes. The SCA also emphasized the nature of Section 16.2. They called it a remedial power.
Meaning it's there to fix a problem or provide a remedy.
Exactly. It's designed to prevent harsh outcomes, like losing valuable rights just because of a procedural slip-up, like missing a deadline. And courts generally interpret such remedial powers broadly, generously, not restrictively, especially not restriction by mere implication from a regulation.
And the previous cases the High Court relied on. The SCA looked at those too and said, well, they were different. They didn't involve this specific interplay between a broad statutory power, like S16.2, and a regulation worded like Reg 83. So they weren't really on point.
Okay, what about the High Court's worry about uncertainty and endless extensions?
The SCA addressed that directly. They basically said that fear was more imagined than real.
Why? Because the registrar can't just grant extensions willy-nilly.
Precisely. The power under Section 16.2 is discretionary, but it must be exercised judiciously. That means the registrar has to weigh things up fairly, consider the reason for the delay, the length of the delay, potential prejudice to the other side, the overall interests of justice. It's not an automatic green light.
And the Act has other built-in protections too, right?
Yes. The court pointed to things like the initial advertisement requirement for restoration, Section 47, rules that protect people who might have innocently started using the invention while the patent was lapsed, Section 48, and limits on damages for infringement if someone didn't know the patent existed, Section 66. These all help manage uncertainty.
So, putting all that together, the wording of Reg 83 itself, the Act over regulation principle, the remedial nature of S16.2, distinguishing previous cases, and the existing safeguards.
The Supreme Court of Appeal concluded that the High Court had definitely erred. Regulation 83 simply did not curtail the registrar's power under Section 16.2 to grant an extension even after the original deadline had passed and the deemed abandonment had technically occurred.
The registrar did have the authority to grant that two-day late request for an extension.
Correct. The power remained intact.
So the final judgment.
The SCA upheld Trustco's appeal. They completely set aside the High Court's order.
And what did they replace it with?
They replaced it with an order dismissing Vodacom's original appeal against the registrar's decision.
So effectively, the registrar's first decision, the one granting Trustco the 2-month extension, was confirmed as being legally sound.
Exactly. The registrar's decision stood, Trustco got their extension, and their path to potentially restore the patent was reopened.
Wow. So quite a journey. We started with what seemed like a simple missed deadline.
A failure to pay a fee, then a failure to file a response on time.
And ended up deep in the fundamental principles of how courts read and interpret laws, especially when different parts seem to conflict.
We really saw how the SCA had to clarify that relationship between a broad power given in the main law, the Act, and a specific, potentially limiting provision in the supporting regulations.
And the crucial takeaway, I think, is how much turned on the precise wording, the fact that Regulation 83 didn't expressly provide otherwise, and in fact seemed to acknowledge the registrar's power.
Combined with the principle that the Act generally holds sway over regulations. That was key. It showed the deeming provision wasn't the automatic kill switch the High Court thought it was, at least not for the registrar's power to grant extensions.
This case really highlights just how critical that precise legal language is. That difference between an express limitation and something merely implied or assumed, well, it can mean everything.
It could be the difference between owning a valuable patent and losing it entirely over a procedural step.
So here's something for you, the listener, to think about. This whole case is about balancing certainty, the need for clear deadlines with flexibility, the need to avoid overly harsh results from minor slip-ups. How do you see that balance playing out in other systems you interact with?
Yeah, think about tax rules, planning regulations, even internal company procedures. How much discretion should officials have? How clear do the limits on that discretion need to be? And how do these interpretations affect innovation, business decisions, and just general certainty for everyone involved? It really shows the ripple effect of these detailed legal interpretations.